Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya matinyana.
The last Saturday of the month of March 2025. It's a Saturday afternoon, so bright and sunny and golden in the sky, and BWTV is live with the community and the law. We're going to look at how to calculate time to indefinite leave to remain. We'll be looking at key considerations under Section 3C and paragraph 39E. A resource person from BWF Solicitors or Lawyer Charles Asma will be on hand to help us to do that. So tell the other person to tell the other person, and let's come together for the community and the law. Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
You're welcome to another edition of the Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. We find them on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And when you get in there, all your legal matters are given a rest. And you have the confidence to tell other people that you have had a great experience. BWF Solicitors, when it comes to immigration matters, they are unrivaled. When it comes to the interpretation of the law, they do it so very well. And the success rate is something you will be excited about. Now, ladies and gentlemen, this afternoon, we're looking at a very interesting topic. How do you calculate the time from the beginning of your stay in the UK to the time where you'll be granted indefinite leave to remain here in the UK? We're going to look at key considerations under Section 3C and paragraph 39E. Do they go together? Does one conflict the other, or they are just complementing each other, or what the case is, we will know at the end of our discussion. And I am happy to announce that we have as our resource person and guest from the fold of BWF Solicitors, our brother, lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Rakuku.
Thank you for joining us. I know your Saturday afternoons are quite precious. So when I have the privilege and opportunity to host you, and also you empowering the community, I'm so excited about that. So with all excitement and heartfelt gratitude, we say welcome to the show.
Thank you. Thank you so much. It's a
And
pleasure to see you.
well, yes, you will have a whole lot of experience from what he's going to help us calculate and discuss this afternoon. But before then, let's see. Gratitude is one of the things that really help us to move on in life. And when somebody does something for you, I know you would have to show gratitude. And Lauricia is doing same. Loisha says that she walked to the offices of BWF solicitors to discuss her British citizenship application with lawyer Charles Asma. Lawyer Charles Asma advised her and made everything seem so easy and simple. A few weeks later, Lawyer Asma called her to say that her application had been successful. So what Lorisha is saying that I'm going to recommend Lawyer Charles Asma to anyone who needs immigration support. He's a classic gentleman. I'm so happy. Lawyer Asma, this is another feather in your cap.
Well, it's a feather in the cap of BWF solicitors as community lawyers. We are grateful that our clients are happy and will continue to do the best to make sure that we use the law to empower and to liberate.
Mhm.
So, thank you to Laurentia for appreciating and knowing that, just like anybody else, when people can walk into our doors, we analyze their case, make sure that the case has a chance of succeeding. And where the chance is not clear, we'll discuss with them what they have to do to improve that chance. And this is what we do.
Well, thank you very much. Keep doing what you do. And I believe that whoever wants to experience same and express same, you can visit the BEWF solicitors offices, as I keep saying, on the fourth floor of the Young House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Listen, just give them a call and things will start going so very well for you. 0208 493 7340. 0208 493 7340. In Ghana, the office number is 055 589 5959. In emergency situations, you can call 077 127 61884. 077 127 61884. BWF solicitors are trusted partners when it comes to the law. So, Laurentia, thank you. So, whoever has that experience as well, please let them have it, and we will bring it out for us all to share. There's an update in the community. Minimum salary, that is a going rate for healthcare workers, is increasing from the 9th of April 2025. The minimum salary threshold for skilled workers, as I said, will increase to £12.82 per hour or to £25,000 per annum from the previous level of 23,200. So if you are in the healthcare sector, good news, your minimum salary is increasing to £12.82 pence per hour or £25,000 per annum. Initially or previously, it was at 23,200. So take note of that and keep working with a smile. You see on the pictures there, yes, they were helping people, so they give us that toothpaste smile every day. Keep working and keep working hard. We appreciate you. We love you as well. So, yes, we'll move on to our nugget, which is giving out every Monday morning. And we help the community to have such pieces of information to enhance yourself and empower yourself. The question we asked this week was that if you knew the 180-day absent rule or absence rule does not apply to individuals with a spouse or partner. Did you know? Well, let me tell you that, and I'll go for some explanation from our beloved lawyer Charles Asma. Under immigration law, absences from the UK are limited to no more than 180 days in any 12 months to ensure that an application for indefinite leave to remain is not affected. This rule does not apply to spouses or partners who hold visas issued under Appendix FM. However, the applicant and their partner must intend to live permanently in the UK. Remember, it is important to note that frequent or lengthy absences could raise doubts about the couple's intention to live together permanently in the UK. Thus, is based on paragraph ELTRP 1.10 Appendix FM. Lasma, this is your English. Can you please Break it down
Right.
for us.
Sure. So we have range of entry clearance or range of visas. One of such visas is visas issued to partners, and that and you can see that is appendix FM matter where we are looking at the fact that people should not stay away from the UK for more than 6 months or 180 days if they intend to be resident in the UK. So if you are not resident in the UK, or if you do not continue to remain in the UK, you travel and you are always away for more than 6 months, then someone will conclude that maybe the person does not intend to be in the UK. Let's note that intend to be in the UK. So anybody who has to be in the UK for some other reason must intend to be in the UK.
Mm.
What if I I am in the UK because of my husband or my relationship with my spouse, my husband or wife?
Hmm.
Intending to be in the UK, is it the same as intending to be with your partner? They are different, aren't they?
To be in the UK and to live,
Intending to
yeah,
be in
yeah,
the
they,
UK,
they, they obviously different, yes.
they are very different. And therefore, intending to be in the UK is general. Intending to be with your spouse or husband is the relationship bit.
Hmm.
And we also know that the relationship is not geographical. Relationship is heart based, isn't it?
Yeah.
It's a matter of love, and love is a matter of heart. And so, even if I'm not physically in the UK and I can prove that my spouse's mind, being, everything is in my heart, then the relationship is there, isn't it?
Yeah.
And so we are looking at distinction between people who must follow or keep to the letter and spirit of the 180-day rule. You travel, you have to be back. You don't have to be away for more than 6 months or 180 days. And people who travel and they are back to continue their relationship, not back to live in the UK.
Okay.
Therefore, if I'm away and I'm not back after 6 months, but I'm able to still prove that I'm able to continue to be in that relationship so that the relationship will remain subsisting, then you cannot use the 180-day rule to punish me. Because mine is a matter of love. The other people is a matter of geographical presence.
Hmm.
So the rule, paragraph E, which is the eligibility criteria part, limited leave to remain, partner 1.10, says that even though the rule is that you have to be back not more than 6 months or 180 days, this rule is for general people, quote and unquote, and not necessarily spouses. For spouses, you just have to show that the person's being is still in your heart, and therefore the relationship is still ongoing, and that you intend to live permanently with the person in the UK. Intending to live permanently with a person in the UK is everything else, and not necessarily the fact that when you travel, you return within 6 months or
Okay.
180 days. So the criteria that or the rule about no more than 6 months absence does not necessarily apply to spouses. Because if you're a spouse, remember you can return within 6 months, but if the relationship is broken down, you will still be refused the visa when you are
Okay.
renewing.
Okay.
So it's not about geographical presence, but presence in the relationship with your partner. And if it is UK that you have decided to have your relationship or have your life, then you intend to live in the UK permanently. So what has that this got to do with anything? What we are saying that if you apply as a spouse, you are in the UK with your spouse and you travel, and for whatever reason you are not able to return within the 6 months, it will not be used against you. What you have to show is that there is still intention to continue to remain with your partner permanently in the UK.
Okay.
And that's the caution, though, is that if you take advantage of this flexibility and you are always away, you are always away, and you are always away without your partner, then the presumption will be raised that it appears that the love is waning.
Okay.
And if love is waning, then the relationship may not be subsisting. If the relationship is not subsisting, then it will affect your ability to continue on that visa category or route.
So,
So,
so in effect, lawyer, you're saying that in all situations, common sense must apply here. That yes, you want to maintain that your relationship is subsisting. You would want to avoid a situation where somebody would doubt your relationship. Then you may want to look at how long you stay outside of the UK or how often you go in and out, isn't it?
yes, it's very important because if it is concluded that you are always away from your spouse, you're always away from your spouse. And as I said, somebody can stretch the argument you say, then this is going to affect the love. But we also know that the rules under paragraph RWP 6.2, relationship with partner, says that the relationship must be subsisting. Again, the relationship must have been at least 2 years and not necessarily living together. So if living together has been taken out of the equation, then you don't necessarily have to live together. So if I'm away from my husband or wife for 6 months, more than that, or 7 months, 8 months, or whatever the period, and
Mhm.
I return, it doesn't mean that I'm late and because I've stayed away longer than usual, it's affecting my relationship. Unless there are other factors to suggest that the relationship is broken. And as a result of that, it is no longer subsisting. Then that will affect. So for you as a partner, you are not so much interested in the absence, but you are interested in whether the absence is going to affect your ability to remain with your partner in the UK permanently. If it is not affecting it, then you cannot be punished for that absence.
Okay. Right. So what we have actually discussed and lawyer has explained is that the immigration law absences in the UK are limited to no more than the 180 days as we discussed. But it does not apply to spouses or partners who hold visas issued under Appendix F. And for further information, you can quickly give BWF solicitors a call on 0208 493 7340. 0208 493 7340. And you can also call lawyer Charles Asma directly on his line. He calls it the line of hope. So, yes, trust it and you will benefit from that. And it's 07947 636037 You're live with us on the community and the law. We've looked at our nugget. We looked at the update we have, which is the annual salary of healthcare workers that is going up. And we've looked at um, the 180-day absence. And of course, Laurentia's our appreciation. But then let me also test you on this one. Let me give you a scenario. Abner Kunkonsa is a Makola businesswoman. Now, Abner moved to the UK to join her husband, Yao Innocent. Abner was granted a 30 months leave to enter. Now, in the second month, she moved to Ghana to continue with her business. She was therefore absent for 9 months in the first year and 10 months in the second year. Abner, at the moment, is worried that her visa application for an extension will be refused because she stayed away from her husband for more than 6 months in each of the 2 years. Now, think about it. And I'm asking, will the application be refused? I'm not going to consider application. Would they be refused? Three options. Yes, because she stayed away for over 6 months in the past 12 months. No, because there is no limit on the period of absence. And C, no, but she must show they have the intention to live permanently in the United Kingdom. Think about these, and when we have had our discussion, I'll come back to it. In the middle of the discussion, I'll remind you, yes, and then you give me the answers for me to be so sure that you have been really empowered by the information we give you in the nuggets as we discussed earlier on. It's a community in the law. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And welcome back, and thank you for sticking around. We're live on BWTV, at BWF Solicitors on Facebook and YouTube, at BWTV on Facebook and YouTube. If you would want to put in your question or your concern, you can put in the comment section down below, or send it via text to us on 07399 208 438. And then also, when the lines are active, you can call in on 0208 493 7345. Now, time for action. We're going to have a discussion. Then we are going to look at how to calculate time to indefinite leave to remain. And we're looking at Section 3C and Paragraph 39E considerations. So I definitely, you would be asking, what do we count and where do we start counting from? Where do we end? What are we talking about as Section 3C and Paragraph 39E? Listen, don't panic. There's no need to worry, because Lawyer Charles Asma is here, and by kind courtesy of BWF Solicitors, we will know. Lawyer Asma, calculating our indefinite leave to remain. Where do we start? Where do we end? And where do we go? Please take a seat.
Thank you very much. Viewers and listeners, today's conversation is fact and law. And so we have to work with calculators. The moment you see calculate, it means mathematics, but we'll keep it simple and relevant. We are looking at 4 pieces of law in this conversation, and a lot of things that have been happening. When somebody thinks that they are due to make indefinite leave application, it turns out that they are not. What could be the reason why, when they thought they were, Home Office is saying they are not. We'll be putting all this together and be clearer. While by the time we finish, we would have been clearer on how to calculate your own time so that you are clear that you'll be due for indefinite by this date.
Mm.
So we look at different aspects of visas. We have work visas, that's one category. We have family visas, another category. We have student visas. We all these aspects of visas, one way or the other, do count towards indefinite leave to remain. But in terms of the threshold, they vary. For example, work visas, you stay for 5 years and you apply for indefinite.
Mhm.
And so such a person will have to remain with the employer for that 5 years. And once they've covered, they will have to apply for indefinite leave to remain. And so the level of discretion is very minimal because you just have to tick the boxes throughout. So that is, again, the person might, when they are ready for renewal in between, somebody who is given, let's say, 2 years, and after that they renew for 3 years. The same employer, but they have to renew. If you are with the employer and the visa expires and you've now obtained the sponsorship or renewed sponsorship, then it will be difficult for you to be able to extend. But somebody will argue that can the person extend under paragraph, for example, 39E of the rules, which says that if you are late, you still have 14 days. The person will argue and potentially win. What it means is that where the person had a break between the first skilled worker renewal, the first skilled worker visa, and the subsequent renewal, then going for indefinite leave 5 years later may be the case that the person will have to bear in mind this conversation because you didn't continue throughout. At a point in time, there was a break. So whenever there is a break, i.e., under the 5 year route to indefinite or 10-year route to indefinite,
Mhm.
that break will affect your time. And it is important that we note that.
Okay.
There are, as we said, there are some pieces of law. The first piece of law is the Section 3C of the Immigration Act of 1971, which says that anytime you have no break in your visa, whenever you make an application and the application is pending, your protection, as far as your rights are concerned, will remain. So the key word here is break. If
Yeah.
there is a break, then it will be a different conversation. Where there's no break, it doesn't really matter how long it takes for a decision to be made. So let's bear in mind that Section 3C says that where there was no break between the expiry date and the time you renewed, you don't really care how long it takes for the decision to come. Your protection remains with you. Paragraph 39E of the immigration rules point out that we are all human, and therefore, when somebody slips, do you punish them or you give them opportunity to make amends? So that is 39E. So 39E says that it's possible there could be a break, but if the break is not that serious, then you can be pardoned. So somebody whose visa, for example, has expired yesterday and they are making application today to renew. And that's why I started with even skilled worker. If the person's skilled worker, for example, expired yesterday and their COS renewal came today, they're already late one day, aren't they?
Yeah.
If they make an application and argue that one day should not be held against them or they should not be punished for that one day delay, then their visa will be granted under 39E discretion. However, when they are ready for indefinite, then it's going to be opened up again for conversation. And that is what we'll be looking at more today.
Mm.
The third one, or the next bit, is paragraph 276B. Paragraph 276B of the immigration rules.
Okay.
Paragraph 276B of the immigration rules say that for anybody apart from those who are on the 5-year route to qualify for indefinite leave to remain, and of course, we are also not looking at EU. So this one, no EU consideration. And also those under skilled worker or work permit are also different.
Okay.
And also those who come in as spouses 5 years. Also, we have people who have 5-year route and those who have 10-year route. But generally, what it doesn't really matter. What 276B says is that if you are applying to remain in the UK indefinitely on the basis of your long continuous residence in the UK, then such long continuous residence must be 10 years.
Okay.
And that tells you why, within the scheme of things, the policy for 10-year route was designed to cap it up to 10 years before you go for indefinite, because 276B says that to be able to qualify for indefinite, you should have lived continuously and legally in the UK for 10 years.
20 years, yeah.
So somebody will put all bit together, and they've lived legally, continuously for 10 years,
10
then
years.
they qualify for indefinite. There are also applications that will be granted, or visas that will be granted, and the person must hold it for 10 years,
Mm-hmm.
inclusive of renewals. Hold it for 10 years before they apply for indefinite.
Okay.
So there are two platforms or gateways. Gateway number one deals with those under 10-year route. And gateway number two deals with those on the 5-year route.
Okay.
It doesn't matter whether 5 or 10. For us, what we are interested in is whether there was a break in the renewal process up to the point where you exhausted your time, whether under 5 or under 10. Was there a break during the renewal process?
Okay.
And if once we identify that there was a break, we are looking at whether this person will benefit from the break or not.
Mm-hmm.
So there are two benefits platforms. Section 3C benefit, which says that if there's no break, then continuously when you are due for your indefinite, you apply. You don't have to bother about any time constraint. Paragraph 39E says that when there is a break, when you are due for indefinite leave to remain, ask yourself who pays for that break.
Okay.
So if there is a break in between the renewals, then you pay for it. If there is no break, then you don't have to worry about paying for that. When we say pay for it, we don't mean pay money for it, but you have to make time
Make up the
for it,
time
make
if
up the time
it was
for
any
that.
period within that segment, then you make up that time. So you don't say that, well, my 10 years ended on the 31st of March. Meanwhile, there had been a break of about 2 3 weeks. Then you would have to top up from the 31st of March with the 2 or 3 weeks that you had a break for. Is that what it is?
That's the point.
Okay.
So, producer, if you're available, if you could help us with that legal point, if you have the resource
Yes,
available.
whilst we're getting that ready, I just want to
Yes,
reiterate that you live with us on the community and the law. And it's brought to you by BWF Solicitors. This afternoon, our guest and resource person is lawyer Charles Asma. He's taking us through how to calculate indefinite leave to remain period. And we're looking at section 3C and paragraph 39E considerations. There, we had a document on earlier on. So let's go back to it and follow the discussion on that.
right. So we have 39, I think we've mentioned the 3C, which says
Yeah.
that where there's no break, your time is the standard limit. So
Mhm.
if you're under 5-year provision, up to 5 years, after that, you apply for indefinite. If you're on a 10-year provision, up to 10 years, you apply for indefinite. So that's 39C, where there's no break at all in the renewal process.
Okay.
Paragraph 39E of the rules say that where there is a break, then we have to put it aside because that will be used against you when you come for your indefinite or when your time is due for indefinite. We know that paragraph 276B of the rules say that to qualify for indefinite, you should have lived in the UK continuously and legally for 10 years. Continuously and legally. What it means is that there might be some point where, even though you are in the UK, your presence will not be counting. For example, if you are in prison, then that will not be a counting presence and some other factors. But we are assuming that all those factors are constant. And so 10 years continuous residence in the UK legally, you qualify for indefinite leave to remain. What about those people who have done 5 years because their visa is taking them up to 5 years for indefinite qualification? Then 276B may not necessarily apply to them because they don't need to do 10 years. They only need to do the 5 years to qualify for indefinite. However, 39E applies to everybody. For 39E, where there is a break, so we'll take a scenario later on. However, in 2022, 2022,
Your, your,
2020,
your, your producer is multitasking, don't worry.
yeah, I agree. 2022, 2021, there was a shift in this legal discourse. So 2019, down, down, down. Even if you were late, it will not be used against you. And that was the beauty of that. But 2021 coming, if you are late, it will be used against you. So the question is, what happened? So there's a case called Afzal. Afzal is a court of appeal case. And I'll just give brief because that will apply to so many people. Afzal applies for renewal of his 2.5. Afzal applied for fee waiver. Fee
Mhm.
waiver was rejected. Afzal was given 10 days to pay the money and submit the main application, or so 10 days you have to pay and submit the main application. That's what he did. That's what he was supposed to do.
Mm.
For whatever reason, he decides to make another fee waiver application. Then or he decide not to. So whether you forgot about it or you didn't forget or whatever happens, so a lot of people will say, like, can I do a new fee waiver? If my first fee waiver has been rejected, that will go against you. Or I'm looking for money to pay. And if I don't get the money in the 10 days that I'm giving, what happens? So this is what happened to our friend, Mr. Afzal. So instead of submitting within the time period, he forgot or he didn't. And as a result, by the time he was ready to submit the application, he has fallen into the 39E provision. Then, when he was due eventually for indefinite, Home Office refused the visa or the indefinite leave to remain application. And he was told that sometime back during the renewal process, he didn't submit application on time. He was granted the renewal. However, it doesn't mean that he doesn't have to pay for. So he took the matter to court, and Court of Appeal concluded that because of the delay, And because of the delay from the home office, you have to pay for those 2 delays. So it is not time for you to make indefinite leave to remain application. Then we go to our friend Iyeki. So
Mm-hmm.
producer, if you can show the first slide for us, please. So our friend Iyeki makes application. Application was refused. And you can see that Iyeki's case traveled up to Supreme Court. Application
So you
was
mean you
refused.
mean Iyeki versus the Secretary of State Home Department, a
Yes.
2022 case?
Yeah, 2022. Yes.
Okay.
So AXA was the one we discussed. That one was up to Court of Appeal. Iyeki traveled up to Supreme Court. Iyeki, the spelling is E at the end. Iyeke. So please pardon me for the typo. It's Ke, not Ki. Iyeki. So Iyeki makes application, he's refused. And he's supposed to go to court because he was given right of appeal. He didn't exercise the right of appeal within the 14 days. He makes application to court for extension of time to appeal. Court agrees to grant extension of time, and his appeal was accepted and considered. Eventually, he wins, and the Home Office grants the visa. Eventually, when he was ready for indefinite, they traced back to where there was a break between when the visa was refused and when he eventually sent the appeal to court. And they said that because of that break, he has to pay for it to make extra time. So we've looked at 2 instances where you make application to renew your visa and you don't do it on time. Or you make application, you are refused, and appeal was not submitted on time. But eventually you succeed at appeal and you get the visa back. Either way, that gap, you have to pay for it or cover that bit under 39E. So we have understood the legal permutations.
Mm-hmm.
We are not worried about 3C because 3C, we know that you are a saint.
Okay.
So 3C is for saints. Nothing wrong. Everything is on point. So you don't have to worry. 39E is where you have an error or you've committed a mistake or made a mistake
Mm-hmm.
by not applying on time.
On
And so
time.
there's a gap.
Mm-hmm.
Your own gap, which is the delay, and home office gap, which is the delay. We'll look at accumulated gap and we'll give it to you to pay for it. When we start the calculation, you will note that.
Okay.
So you see that up to 2020, this wasn't the case. As long as your visa is accepted and you are granted, you don't worry about what will happen when you get to indefinite leave to remain threshold or
Mm-hmm.
period. 2021, 2022, up to today, that is happening. So the court concluded that 3C is for saints, and therefore it does 2 things. It shields you, and you can also use it as a sword to gain anything you want in terms of getting to your indefinite leave to remain.
Well, I think maybe we could put it this way: it's for saints. It's for those who have not made mistakes, those who have not had gaps.
I agree. Right, right. Yeah, I agree. Yeah, I mean,
Yeah,
I try to use this analogous point
I
to.
know, I know.
Yeah, so for those who don't have gaps,
Hmm.
in between the renewal periods, 3C covers you throughout, up to indefinite.
Yes.
But those who have had gaps, 39E will cover you because you are still given the grace period.
Hmm.
So when you operate within the grace period, that grace will not follow you to indefinite.
That's right. Yeah.
But when you operate, so more or less, the grace is there, but don't go close to it if you don't want trouble when you get your
Stay
indefinite.
away.
But this is immigration grace, not
And
visa
I
grace.
get it. I get it. Well, folks, we're looking at calculating time to indefinite leave to remain. The two things that Laura has really pointed out. And what he's talking about is 3C and paragraph 39E. Now, 39E is where he's explaining that there may be gaps within your period, but what it is that if the gaps are there, you would have to pay for the time that you lost. So, for instance, in calculating, you realize that in say year 2 or 3, there is a gap of 2, 3 weeks, or maybe even a month if it's allowed. Then when you think that your indefinite leave period is up, you would have to look at that gap and use the grace or the provision made by paragraph 59E to say that yes, you have extra time to make up. So you don't put in your application when it's not due, or you would have to calculate it till the time where you have paid for the lost time. Those are things you need to consider. Now, he's going to help us to start the calculating, the counting. He mentioned earlier on that we would have to get our calculators ready. We're doing some mathematics here and there, but it's going to be very, very simple. So get yourself ready. I'll take just a quick break to announce what BWF solicitors are for, where they are, and what they do. And when we come back, we'll get into the maths. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, welcome back, and thank you for sticking around. Like the page and then share as much as you can. Did you know that the 180-day absence rule does not apply to individuals with a spouse or partner? In our discussion, Lawyer Charles Asma has mentioned the breaks here and there. Under immigration law, absences from the UK are limited to no more than 180 days in a 12 months to ensure that an application for indefinite leave to remain is not affected. This rule does not apply to spouses or partners who hold visas issued under Appendix FM. However, the applicant and their partner must intend to live permanently in the UK. It is also pretty important to note that frequent or lengthy absences could raise doubts about the couple's intention to live permanently in the UK. So, based on that, I had this question about my friend Abla Kokonsa, who um, is a businesswoman in Makola in Ghana, moved to the UK to join her husband, Yao Innocent. Abna, when she came to the UK, was granted 30 months leave to enter. In the second month, she moved back to Ghana to continue with her business. She was absent for 9 months in the first year and 10 months in the second year. Now, Abena at the moment is worried that her visa application for an extension will be refused because she has stayed away from her husband for more than 6 months in each of the 2 years. So, my question is, will the application be refused? I've given you three scenarios. Think about them. Yes, Abena will have her application refused because she stayed away for over 6 months in the past 12 months. No, it will not be refused because there's no limit on the period of absence. And would the application be refused? No, because um, let me put it this way, no, but she must show that they have the intention to live permanently in the United Kingdom. Think about that. We'll come back to this at the tail end of the program. But we're going back to our discussion. Remember, we're coming your way courtesy BWF solicitors are trusted partners when it comes to the law. And they bring us the community in the law every Saturday afternoon between 4 and 6 p.m. UK time. This afternoon, we have from the stables of BWF solicitors our lawyer friend and our teacher, so to speak, lawyer Charles Asma. We calculating time to indefinite leave to remain. Is looked at the key considerations under Section 3C and paragraph 39E. Now, we're dipping our hands into the whole meal. How do we do the calculation, lawyer?
Thank you very much. So we have understood the various permutations.
Mhm.
Let's take our first scenario, and this is John. So, do we have John's story ready, producer?
Yeah.
So, this is John. So, Braco could help us with John's story.
Yeah, John's story goes like this. He's held 2.5 years under 10-year route twice. He applied for the third 2.5, 10 days late. He was granted 1 year later. When is John due for indefinite? So he's held
Right.
2.5 years under 10-year route and he's had it twice. He applied for the third time. So my understanding would be, let me test my knowledge, lawyer. My understanding is that he will have 2.5 years 4 times, right?
Yes.
Okay. So he's done the first two. He
So,
applied
the
for the
first
third
two,
one and was 10 days late.
yes,
Then,
but he was
even
granted.
though he was 10 days late, his visa was granted 1 year later. So I'm looking at where he is late for 1 year, 10 days.
Good. So the starting point is to establish the gap,
Mm-hmm.
that the accumulated gap, because the gap is made up of his own making and home office making.
Yeah,
How what is his contribution to the gap?
10 days,
And what's home office contribution to the gap?
1 year.
1 year. So the accumulated delay is a year and 10 days, right?
Mm-hmm.
So we have to either he will change all to days or he knows that at least is 1 year. It's easy to know that 1 year. So let's assume that our friend John is to end the 10-year gap or the 10 years continuous residence. So the
Mm-hmm.
second 2.5, third 2.5, the fourth 2.5. We know that he was granted 1 year later. When is he due? We are doing this on the basis that he has finished everything. Even after the third one, he went for the fourth one. There was no issue about the fourth renewal or the
Mm-hmm.
last renewal.
Okay.
The issue occurred during the third renewal, right?
Mm-hmm.
So it doesn't really matter where the gap occurs. It can occur when you are renewing the second time, the third time, or the fourth time. Yours is to ask, where did the gap occur and how long? We know that 1 year, 10 days. He's ready according to the original grant of leave. His 10 years will be today. So he thinks that from tomorrow he will apply for indefinite. And you have pointed out to him that, hang on, The case of Afzal and the case of Iyeki point out that even though he was granted on mercy grounds, and
Mm-hmm.
it was just a shield. And so he cannot use the same mercy to go for indefinite as a sword. So he's asking you, so when do I go for it? How long should I wait for? So he's going to wait for 1 year, 10 days. So let's just do the simple calculation. If today is the 10 years and he was supposed to do it, and we know that he has to wait for 10 days and a year, then the next year will be 2026, right?
2026 in March.
20, March 29th, right?
Mm-hmm.
Plus how many days?
Plus 10 days.
So
So
then we have
March
to
is
add it.
31. So 20, today is the 28th. No,
So
29th.
two. So two, isn't it?
2, then 12 days in April, he would have to, that's when it will end, isn't it?
So if it is two, he has 10 days to make up. But the 10 days ideally would have been 10th of April. But we know that he has 2 days in March because today is 29th.
Mm-hmm.
So 29th, let's so tomorrow 30th, and the next day
30th,
30th, 2
31st
days. So 2 minus 10 or 10 minus 2 will be
is
8. So
8.
8th of April.
8th of April. Yeah. Okay.
So so we know that because of that delay caused by himself 10 days and caused by Home Office 1 year, he has to wait until April 2026.
Now, the question obviously will be that the 1 year that the Home Office delayed wasn't a friend's fault. So why does he have to pay for that?
So there's something called chain of causation.
Mm-hmm.
So we have to establish whether the delay by the Home Office was caused by Home Office or was caused by him. And that's why Home Office says that if you don't have any issue, if we don't have any delay from your side, then any delay we cause will not be used against you because section 3C will cover you.
Okay.
But the moment you cause delay yourself, our delay will be added to your delay.
That's not fair. Lawyer, that's not fair.
Well, there's no fairness in the world. It is what it is. So, yeah, you can say it's not fair, but they will also say, well, but you caused it.
You caused
You
it.
you made us do it.
Mm. Well, so in this case, the delays are of two different types. One caused by you, the applicant, and the other caused by the issuing authority, which in this case is the Home Office. And you would have to pay for that. So you cannot say that you would be due indefinite 1 year earlier because your application stayed with the Home Office for a year. And even before that, you had delayed for 10 years, for 10
10
days,
days.
sorry.
Yes.
Okay.
So the question is, did John renew at any point in time under 3C or under 39E? And we conclude that he did so under 39E because he delayed for 10 days.
Okay.
So Home Office will invoke the ruling under Afzal Court of Appeal 2021 and Iyeki Supreme Court 2022 and say that the delay caused by us was as a result of your own delay. And so your indefinite is not due yet. So in that case, the person will be granted another 2.5 to make time to wait till. Just that he wouldn't have to wait till the end of the granted 2.5, the last one, which is given. Because if the Home Office says that we won't give you indefinite, then you are going to be an overstayer.
Okay.
So they will ask you to pay for the IHS fee
Mm-hmm.
so that you are granted 2.5 to survive.
Okay.
But that 2.5 is not what you asked for.
You asked for indefinite, but they say
You
you are
asked for
not due.
indefinite.
So we're giving you another 2.5 so you don't become an overstayer.
Good. In this case, Even though he will be given 2.5 so that he doesn't become an overstayer, he doesn't have to use the whole 2.5. He knows that he has to apply by 8th of April 2026 per the
So
calculations.
in this case, say when um, in April 2025, he thought that he was due indefinite, puts in an application, and the Home Office says that um, you are caught by paragraph 39E. So you will be given another 2.5 years. So you pay your IHS fee. Now, April 2025, 2.5 years will be um, April and 6 months down, and that will be in August or September 2026, for instance, 2027, for instance. When he gets to April 2026 and his time is up for him to apply again for the indefinite leave to remain, will Home Office say that you made an application, we made you pay the IHS, so we're granting you the indefinite leave free of charge, or you have to pay for another application fee?
Oh, that's a good point. That is something that he should have picked up, because if there is any need for refund, you seek the refund in isolation,
Mhm.
not as a way of set off against what is due you.
Okay.
So you can't say that you owe me the other one I paid,
Mhm.
so this one I won't pay. But how would they know that you are submitting an application?
Okay.
They don't know what you are doing until you have submitted.
Right.
So if you say that you owe me and so give me the money to pay for it, then you have to write to them for them to give you the money so that you can submit your application, right?
Yeah.
And if the money doesn't come or refund doesn't come and you run out of time, whose fault?
Well, you didn't ask, so it would be your fault. So long as you had triggered 38E, then you
39 you
have to
mean?
be a lot more responsible. Then you have to ask for things, isn't it?
No, no, yeah, no. What you are saying is that, but if the person has been given 2.5, they've already paid 2,885.
Mm-hmm.
Why should they pay another money when
Another
their
money
actual
to get the
indefinite
indefinite.
is due?
When he asked for it earlier.
Yeah. So what I'm saying is that don't gamble on that. Just submit by the 8th of April, submit it, the indefinite. Because this
Mm-hmm.
time you get it. There will be no issue.
Okay.
Then later you go back to them to say that, you people already owing me from the last conversation. So when do I get it? Then you take it with them in isolation.
Oh, okay. All right. So if you don't ask, you won't get anyway. Yes, moving on, we have the first scenario, and lawyers giving us um, a friend's situation where, in the midst of the 4 2.5s, he had to, or he delayed and was delayed at the Home Office another year. So 1 year, 10 days. That route. That's scenario one. Um, is there any other scenario given us, lawyer?
Yeah, so the next one that we are going to look at is, if you, I'm going to work with you on that. So this time it's you, yeah, but not you, as in you, yeah, we are using you, yeah. I know you don't need 2.5, but on this occasion, it's your
Well,
twin
I
brother.
represent people who need to have. Don't worry.
Very good. Yeah, so it's you. You've just
Mhm.
come to me to say that you came to join your spouse, just like the guy in our nugget scenario. He
Abna
came
Kokonsa.
Abina. Oh, okay. So Abina. Okay, so that one is Abina. Okay. Then Kwabina. Then. All right. Yeah. So you joined your spouse. So yours is under 5 year route, not 10 year
Hmm.
route.
Okay.
You came, then you had to renew the second time. Because the
Hmm.
first one you got it from your country, you came and got your card and you were living. You had to renew, but you were late for 14 days. So you just applied in time within 39E grace period. When you applied, you opted for priority. So the visa was issued within 5 days.
Okay.
5 days. So let's pause here and do the calculation. Your visa was due for renewal. You didn't renew for whatever reason. So you were late for how many days? Your example, 14 days,
14
14
days.
days. Because you did it just the last day of the grace period of 14 days.
Okay.
Last day. So you exhausted all your 14
All
days
your
grace.
14 days. Okay.
The first example we had, the guy delayed for 10
10
days.
days.
This one, you delayed for
14
14
days.
days.
So we
You
exhausted the
applied.
grace period.
You applied for the 2.5 renewal and the 5-year route. You opted for priority service. So you were granted the visa within 5 days.
So you lost 14 days and it was granted 5 days. So I'm assuming you have delayed for 19 days. Well, I said I'm representing people who are on
Good.
the 5-year road, so that's fine.
So today's conversation is about calculating time.
Mhm.
So we've been able to calculate for your case. You've come to me, I've taken the instruction. Your instruction is that you were late 14 days, home office was late 5 days.
Mhm.
Usually, you wouldn't tell me that you were late 14 days. You would tell me that I applied on this date when my visa had already expired.
Expired.
Then I will calculate the days that you had as a delay. And we
Mhm.
know that it's 14 days. You've also told me that you made the application and opted for priority. So you paid £1,000 and it was issued within 5 days. And
Mhm.
I know that Home Office also delayed for 5 days.
Okay.
And you have told me that together there's accumulation of 19 days.
Mhm.
So our friend is supposed to apply for indefinite leave to remain in the last 28 days once this visa is granted.
Okay.
So 2.5 years, the last, which is the second one or the last one, because this is 5-year route. So counting for if not for the delay, his indefinite would have been possible in the last 28 days.
28 days before the last 2.5 expired.
Very good. However, he's already created 19 days extra.
Mhm.
So what it means is that even though the last 28 days, for example, would have been starting today, it cannot start today. It has to start after the 19 days because then it is 28 plus 19,
Okay.
making what?
So
37,
28,
right?
19, 7,
47.
47 days.
47 days. So the last 47 days, you have your own problem there, and you have the standard time that you could have made your application, the last
Mhm.
28 days.
Mhm.
So my advice to you will be that because you already created 19 days, you cannot say that you are due to apply because you are in your last 28 days.
Okay. So
So
then
you
you
have
have
to
to
wait.
pay the 19.
Yes, so you have to wait for 19 days so that you have your actual 28 days there for you to consider to use.
Okay.
Because if you do it now, then you are applying in the last 48, 47 days, which is not the case.
Mhm.
So you have to claw back the 19 days and utilize the actual 28 days. That is the normal rule.
Okay.
So somebody will say, does the conversation only cover 10-year route? No. This is your case, which is under 5-year route.
Okay.
So whether 10-year route or 5-year route, when there is a delay caused by you, you are not protected under Section 3C when you are ready for indefinite. So we've seen two scenarios where the person has had to make up for 1 year, 10 days, and therefore calculating time, he had to wait for 8th of April the following year. And we have another one. In all this conversation, our relevant time for indefinite is up to today. And today's date is 29th of March.
29th of March. Yeah.
Yeah, for simplicity. So if the person is due for indefinite because they have done 10 years up to today and there are delays, then they have to top up. The person has done 5 years up to today, but there were delays, they have to top up.
Okay.
And the 5 years could be spousal 5 years or work 5 years.
Mm-hmm.
And that's why we're saying that somebody will be on the skilled worker route. The person's application was due for renewal. So the employer was supposed to issue or reissue the sponsorship certificate so that the person can use it to make a new application to top up.
Mm-hmm.
The person was waiting, but the COS delayed. And by the time COS was issued, the person's time had already run out, for example, by say 5 days.
Okay.
The person is just lucky and argued that even though I am late to renew, I'm operating under 39E, just for example. And the person's story was accepted and was granted 3 years work visa, skilled worker
Okay.
renewal. Ideally, the person knows that they will qualify for indefinite once they have finished the last 3 years. So that because the rules say that if you are on a skilled worker, 5 years you can move to indefinite.
Indefinite. Yeah.
But this is somebody who had a gap. How many days? 5 days somewhere.
Mm-hmm.
And home office, this person didn't opt for priority. They made a standard application and it took 6 months for
Mm-hmm.
them to get the decision. So 5 days plus 6 months, 185 days, right?
Yes.
So when you are ready for your indefinite, again, you cannot just, if home office will be using the case of Iyeki and Abza against you, then you have to calculate and preempt that they are likely to tell you that you've been late for 185 days
So then you have to pay for that time
by making it up.
and making
But
it up.
then what happens if there is a gap and your visa has expired because the second 3 years has expired? What do you do? That means the employer potentially will have to issue you another COS to make another limited leave application so that you can remain.
Remain. Yes.
So that then it becomes very contentious. What if the employer is not willing? Because to them, renewed for another time and you go for your indefinite. So if the delay is as a result of that, then you will say that you caused the delay for me and home office was just sympathetic to grant me. So maybe the employer will accept it, but that is between you and the
And the
employer
employer.
on matter of dispute resolution, civil matter. But with you and the home office, that will be public law matter. And that's where the home office, if you are insisting, home office will also insist. And even if you go to court on a point of judicial review, home office will say that the rules are clear. And Supreme Court is also clear that the delay must be paid for.
Okay. All right. So what essentially we're looking at here is that when you cause a delay or you don't apply on time, you would have to pay for the time you have lost. And then you also pay the time that your application would be delayed in the hands of the Home Office. That is essentially what 39E is saying. That even though you may be protected by 3C, 39E says that you pay quote unquote for your sins. So remain a saint, do things in time, but if under any circumstance you're not able to do that on time, remember you have to pay for that time. Because when you don't, the Home Office will refer you to the two cases that we have referred to and based on and tell you that 39E kicks in and you have to do that. How you calculate that depends on you, your start date and all that. But if you need any help, what I want to ask you to do is to consult a lawyer who knows what they are doing, especially talking about such lawyers. We're talking about BWF solicitors are trusted partners when it comes to the law. Call them on 0208 493 7340 or in Ghana 055 589 5959. In emergency situations, call 077 127 61884. And if you prefer directly to go to Lawyer Charles Asma, you can call him directly on 07947 And if you need to pose any question, get free consultation outside of the office hours, we do this every Saturday afternoon, and you can call in, put your comments in the comment section below at BWF Solicitors on Facebook, at BWF Solicitors on YouTube, at BWTV on Facebook and YouTube, or you can send a text to 07399208 and we'll deal with that, as we're going to do next on the program after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thanks for sticking around. We have been calculating time to indefinite leave to remain here in the UK. And we've looked at the section 3C and paragraph 38 or 39E, sorry, 39E considerations. We looked at two scenarios, one on the 10-year route, one on the 5-year route. And what we are saying basically, and through Lawyer Charles Asma, is that when you have lost time, you would have to pay back. So your calculation would have to take into consideration the time that you lost, whether you delayed in applying for any reason, or it has to stay with the Home Office for longer than you expected. We are live on BWTV at BWF Solicitors on Facebook and YouTube, and at BWTV both on Facebook and YouTube, and also on your social media platforms. The lines are active now, 0208 or you can send a text or WhatsApp message to 07399208468. Lasma is here, and we shall be picking up your comments from the comment section down below, as I always advise you to do. Let me acknowledge the presence of so many other people who have been with us. We have had you there, and we are so very pleased and appreciative of you being there. Lyrical Black, I am here some. That's very kind of you. Good afternoon, family. Esther J said so. We have Joyce Sewa saying hi to you as well, Joyce. The next person is Nanajima. Nanajima has a question, so I'll throw it straight away at lawyer. So those on the 10-year route for indefinite leave to remain, what documents do they require for their application, lawyer?
Right. Okay. So this is document required for leave to remain application. Obviously, if it is 10 years, you have to establish whether you rely during those 2.5 years, you relied on your partner and children, or you relied on your children as on the direct access route. I will need
Mm,
more information from there. Let's assume that you relied on your child because your baby mama and the baby live somewhere. You still have to show those pieces of evidence. And
mm,
again, because you are applying for indefinite leave to remain, the two critical pieces of evidence will be the life in the UK test and also the English language test, at least B1. You also have to show that you haven't been absent from all your travel history. Your travel history will have to be made available. So all your passport pages, your new passport, your old passport, whatever number of passports you've had, each page must be added by way of copy to the application document. And of course, your relationship evidence, your residence evidence, if you are working, of course, bank statements this month, pay slips 6 months to add to that. But in terms of whether you have to meet specific threshold in terms of income, that's a different conversation because this is indefinite leave to remain. So I suppose I've been able to give you the key things that you will need if you are due for your indefinite.
Well, thank you very much, lawyer. Yes, we keep acknowledging and picking up your comments. Let's go back to the comment section down below. Thank you for your education. This was sent to our WhatsApp message platform. I submitted my passport in August 2024. February 2025, I received a call to pick up my passport or else it will be returned to the passport office. Please, is it possible for the Home Office to decline visa without any response or feedback to the applicant? Lawyer.
Right. I mean, it depends on who made the application. It's likely the application was done by a friend or somebody else.
Mm,
Because if it was done, because the moment they write to you that pick your passport, that means they are corresponding with you.
mhm.
But this wouldn't be the first correspondence. They would have given you decision notice. So if this was your application and you did it yourself, check your email to see whether they have sent you anything. Either refused or not. Before they ask you to pick your passport up, otherwise it will be returned. That means they've been waiting for you to pick it up. So check, were you refused or not? You haven't told us. If you are refused, then you know that there's no visa. There's no way they will ask you to pick your passport if they have not communicated to you already. It is possible that when they write to you that your decision is ready, go to the biometric center for your passport, you wouldn't know whether you've been granted or not. So usually I tell my client that if I haven't received any notice that you have been refused, but I cannot also be sure what is in the passport. So go and pick the passport and tell me. But at least once there's no notice of refusal, it's possible that you have been given, but we are not 100%. Because sometimes the passport will be available for a pickup before the refusal notice is sent to you or to your agent or to your lawyer. So if you want to call later to give us more information, then we can conclusively advise that yes, they can decline. But if they've declined you, then you should know something.
Okay. Well, the advice is call BWF solicitors if you want further clarification and support, or if you want to provide further information on that. The number to call BWF solicitors on is 0208-493-7340. Let's pick up this one from Nanechi Ahine. Will a parent on a 10-year parent route be able to switch to 5-year route if all requirements are met? If yes, then on the 5-year route, can they apply for naturalization immediately after indefinite or 1 year after or another 5 years later?
All right. So let's unpack the story.
Okay.
Parent. So this is a parent.
Mm-hmm.
Parent 10-year route. Switch to 5. Yes and no. Yes, if the person applied on the basis of direct access to the child. But
Mm-hmm.
if the person applied on the basis of Gen 3.2 because they live together as a family, together with baby mama and the baby, then no, because there's a parent living with you, there is a partner living with you there. So if you are living with the baby and the baby's mother, you cannot switch. If you are living alone and baby is living with the mother somewhere, you can switch after the first grant of the 2.5 under the 10-year route. So that's the first part.
Mm-hmm.
The second part is if yes, I suppose the second one is based, okay, if yes, 5-year route, can she apply for naturalization? Okay, let's say yes on the basis that the parent applied under direct access provisions.
Mm-hmm.
You cannot move to naturalization immediately after indefinite because that concession is for British spouses, not parent of British children. So take note. And I
Okay.
think that is the end of the matter for him here, as far as the story is concerned.
All right. Nanechi, thank you for bringing that on. You can keep them coming through in the comment section down below or send them to our text and WhatsApp message. Lawyer, the next question, I think at the back of it, I want to pose this question. When somebody is on a 10-year route and they get their indefinite leave to remain, how long do they have to stay or wait till they are able to apply for naturalization?
Right. So under Section 6 of the British Nationality Act 1981, Schedule 1, it says that a person who has held indefinite leave for at least 1 year can apply for consideration to become a British citizen, having met all the other rules or criteria.
Hmm.
And such a person can be a parent on the 10-year route.
Yeah.
The only exception here is for people who are spouses of British citizens. Those people, they don't have to wait for 1 year.
Okay.
Immediately, you can apply for naturalization.
Okay. All right. 0208 493 7345. That's the number. You can send your text or WhatsApp to 0739920848. In the comment section down below, you can leave your comments there if you are very quick with your texts and your fingers on your screen. How do you do the calculations when it comes to indefinite leave to remain lawyer? Do you start from the date on your first letter of leave to enter or the day you entered the UK? I'm asking those on a skilled worker route, no travels outside of the UK.
Okay, right. So once your visa is granted, you are given limited leave in the passport, which is the visa, the visa itself to enter the UK. But before that, you receive a decision letter. And the decision letter states that you have been granted and your visa is valid from this date to that date.
Hmm.
So, so the decision letter is clear on that on the duration of your visa. Once that one is up, you apply to renew it. The person did not mention the renewal. He said, do you start from the date? Okay, so let's assume you've applied for renewal. So I think the answer is in the decision letter. So you apply, the counting time is the date on the decision letter when the visa starts.
Okay. So, Rex, that's your answer. Need further clarification? You know the numbers to call. The magic number 0208 493 7340. And as I said, if you prefer to speak to Lawyer Charles Asma himself, you can call him directly on 07947 636036. Let's go to Kwame. Kwame says, I have lived here for 25 years but on the 10-year route due for a second renewal this August. Is there any way I can apply for indefinite leave to remain without having to wait until the 10 years have elapsed?
Right, so let's unpack.
Mm,
I've lived in the UK for 25 years. but on a 10-year route. Obviously, you won't come to the UK on a 10-year route. You come and apply to remain on the 10-year route. So let's assume that they came in, they became an overstayer. And while they came in with students, they switched here and there, and they've been on that 10-year route. Is due for second renewal. Okay, second renewal, so still fresh. Second renewal this August. Is there any way I can apply? Oh, really? Right. Kwame, this one there is called ambition. No. Please.
Kwame,
Kwame,
this is called
what Kwame
ambition.
can do, Kwame's question should be, can I cut the time? Is there a way to save time rather than waiting to end 10 years? Then we can have a space for you. In that case, the rules say that if you are a parent and you apply to remain based on your direct access to your child, because the child lives somewhere with the mother and you live somewhere, then you can switch to 5-year route once you have been granted. So August, when you are going to renew in August, apply to renew under 5-year route by meeting the rules, English language, the money 29,000 and everything. And once you're able to do that, you start a journey on the 5-year route instead of continue on the 10. So you are moving from bus to train, or train is faster. Then you stay on the train twice, two and a half, two and a half. Then eventually you're able to save time, because if your visa is expiring in August and you are renewing in August and switching to 5, then you eventually have two and a half, 3 times. So you save two and a half. So instead of waiting for 10 years, you only do 7.5 years.
Kwame, thank you very much.
And sorry, it says that, is there a way I can apply for without? Okay, so I thought it says after. It says without. As for
Without
without, yeah, no, no, no. You can save time, but you cannot avoid the time.
the time. Well, keep them coming through. Earlier on, we discussed calculating time to indefinite leave to remain. Deborah comes in with, Lawyer, I'm married to a man who lives in the UK, but he wants me and my son to join. What documents do I need for my son? Because I'm no more with my son's father.
I'm married to a man
Mhm.
who lives in the UK,
In the UK,
but
yes.
he wants me and my son to join. Okay, so it's okay. So the spouse is in the UK. I suppose it's a British citizen or somebody who has indefinite leave. Okay, my son, he wants me and my son to join. What document do I need? Oh, all right, right. Okay. So your son will be affected by sole responsibility rules.
Mhm.
You don't have a problem because you don't need anybody's permission to travel to join your husband. But you will need evidence that you are married to him and that your relationship is genuine and subsisting under paragraph RWP 6.2 of Appendix Relationship with Partner of the rules. And you also have to show that he works and earns about 29,000 unless he's disabled and receiving disability living allowance, or he's receiving pe- personal independent payment allowance, PIP, or some other disability threshold applied to him where he doesn't have to show 29,000. If he's self-employed, he has to show profit of 29,000 before his tax profit. And of course, you have to do your English language and pass A1 in the country where you are in. You do your tuberculosis test, and all that will make up for the documents you need. For your child, in addition to everything, you must show that you are solely responsible for the control and direction of your child in terms of his well-being and development. And there is a case called TD Yemen. TD Yemen says that if you are relying on sole responsibility, then you have to prove that you are the only one who makes all decisions that affect that child's life, and there's nobody else. If the person is dead, the other parent is dead, use the death certificate to show that you are solely responsible. If the other person is not dead, then you have to prove why they are not around for the child.
Well, keep them coming through 0208493735. You want to do that on the phone, or you can send it to the comment section down below, like Julius is doing now. My sister cannot write Islet. What marriage can I add for her to bring her to the UK? What marriage? I guess you talking about what document or what evidence? Um, no, I don't know whether you can unpick this one.
Yeah, I mean, what is saying that my sister cannot pass the English? Can he? Can she still come? Difficult, because English language is a requirement.
Okay. Well, let's see who we have on the line. Uh-oh. The person is gone off. Okay, if you can call again, please. Your line is cut. Please do call us again, and
So,
we will get you to speak to Lawyer Charles Asma this
so,
afternoon. Keep them coming through. We still have the quiz question to look at. Abna Conconce's situation. I remember I asked you to look at that again, and I'll be bringing it back. This Makola businesswoman who moved to the UK to join her husband, yeah, innocent. Abna was given 30 months, that is 2.5 years leave to enter. In the second month, she moved back to Ghana to continue with her business. She was absent for 9 months in the first year and 10 months in the second year. She's so worried that her visa application for an extension will be refused because she stayed away from her husband for more than 6 months in each of the 2 years. So if she puts in an application, will it be refused? I don't know about that. So you tell me. Hello.
Hello, good evening to our brother from Point Lawyer Charles, and thank you for the good work you are doing for the community.
Thank you for joining us as well. Lawyer Charles, can you hear our brother?
yes, I can.
Very good. Fantastic. Yes, my brother, please go ahead.
Okay, so at the moment I have retained my rights, and let's say on the 28th of April. Okay, so I've retained my rights, and now at the moment my visa will expire in 2029.
Mhm.
But when I calculate my 5 years, it will end on, let's say, 28th of April next month.
Mhm.
So although my listing will expire in 2029, do I have to can I put in application 28 days before the date that I'll be 5 years? Because the 5 years will end on the 28th of April. So I can do the application, let's say, on the 2nd or 3rd, which is 28 days to the day that will fall on my exactly fifth year.
Yes, lawyer.
Yes, you can do that, but just for my understanding, you say that your pre-settled will expire in 2029,
Yes,
Is it
but
2029 or 2028?
2029.
2029, 28th April 2029. And he's asking
Yes.
if he could put in the application the
yeah,
1st or 2nd of April 2029.
No,
no, no. What
because
he's
that's the
asking,
first
what
time
he's
I have the
asking
five
is,
years.
I think he's clarifying. If
Okay.
we can hear. Yes.
I have the story. Don't
Okay.
worry.
Okay. All right.
So what he's asking is, I've gotten the question, but I just want to be sure that what I'm thinking is what it is,
Okay.
because I want to be sure that he has lived in the UK since marriage to that EU partner for 5 years, which is April next month. Is that the case?
Yes.
So you married 5 years ago
Yes.
and you waited some years later before you applied for the pre-settled.
Yes.
That is why it's due to expire 2029.
That when I did the application in 2020, I had the 5 years. Then I retained my right. They gave me another 5 years. So when I calculate from the date of marriage, exactly 5 years will be 28th of next month, which is 28th of April next month. But because
All right.
retain my okay.
Okay, so you married 5 years ago, which will be due
Yes.
April, right? Fifth anniversary will be
Yes.
April next month.
Exactly.
And when were you given the first pre-settled?
That was April 2020.
April 2020. And when did you renew?
Uh, um,
Was it when
yes,
you
I
divorced?
renewed.
Was it when you divorced?
Yes, I divorced after 4 years, which is
Yes.
last year. Yeah,
Yeah. I get that bit. The reason I'm asking all this is to also make a point when it comes to retention of right and when to do it. Because at the time you thought that you were due for retention of right, they came back to tell you that you were not due for indefinite. So they gave you 5 years again, right?
exactly.
Exactly, yeah. So your retention was not from the date of divorce. Your retention is when you are due for indefinite or certain status, but your wife is no longer in your life. So you are using the divorce certificate to replace your wife, literally. And so all it is that because you made the mistake thinking that you were ready, you will only be ready next month. So next month you can apply. You don't have to wait for 2029. So if you are ready, you can get yourself. So the last 20 8 days will be that so if April when in April?
It says 28th.
April 28th.
Yes.
Okay, you can put in next month. Sorry, next week.
Okay. Okay. Okay.
You'll be
Okay.
fine.
Thank. Yes. Okay. And well understood. Thank you so much.
Thank you to you for calling in 0208-493-7345. I think we can take one question or concern before we move on to our quiz again. Can you switch to a dependent visa from a visitor's visa and exceed your stay? Why would you want to exceed your stay? I don't know. Lawyer.
You can't switch from visitor's visa to any other visa. So the word switch is not useful to this person. Can you regularize your stay?
Hmm.
Having become an overstayer because you came with visitor's visa? Yes, you can.
Hmm.
So you can only do that if the visitor's visa has expired, not when it is still valid. So if you are given 10 years visa, then you are in trouble. You have to either go back and apply to enter on a different route or wait till the 10 years is expired before you can apply in the UK. So that is for that person. But if it was 6 months, it's expired, and you have become a parent, then you can apply to remain on the basis of your child. But that visa must expire first. You cannot switch visitors visa from visitors visa.
Well, that's the piece of advice for you. But I need that advice and an answer to the conundrum facing Abena Konkonsa. Abena says that um, she moved to the UK to join her husband and was granted 30 months leave to enter. In the second month, Abner moved back to Ghana to continue with her business. She was absent for 9 months in the first year and 10 months in the second year. She's so worried that her visa application for an extension will be refused because she has stayed away from her husband for more than 6 months in each of the 2 years. So my question is, will the application be refused as Abner is scared off? Some will say yes, because she stayed away for over 6 months in the past 12 months. Some would say no, because there is no limit on the period of absence. And some would also say no, but she must show they have the intention to live permanently in the UK. Okay, I will pause, get you to reflect. In a few moments, I'll be right back to take your answers. We're still live on BWTV, and the program is The Community and the Law. Abna Konkon says situation. What are your answers? Matilda says, thank you. Thank you, Matilda, but you didn't give me an answer. Uh, let's see what else we have on the platform. Tell me, would it be A? Yes, Abner's application will be refused because she stayed away for over 6 months in the past 12 months. Would the application be refused? No, because there's no limit on the period of access. And no, but she must show that they have the intention to live permanently in the UK. Nana Kwame says, yes, the application will be refused because Abena has stayed away for over 6 months in the past 12 years. Godwin thinks is C. No, but she must show they have the intention to live permanently in the UK. George itself thinks is B because there's no limit on the period of absence. Thank you, Georgie. Theresa thinks is yes, Abner will be refused because she stayed away for over 6 months in the past 12 years. Mavis also thinks same, yes, because she stayed away for over 6 months in the past 2 years. Nekia thinks no, but she must show they have the intention to live permanently in the UK. Florence Ahimfo thinks is B, no, because there's no limit on the period of absence. Sorry. Prince Mensa thinks same as Nekia saying no, because there's no limit on the period of absence. Let's see. Susie Paul thinks a C. Abena and Yao must show they have the intention to live permanently in the UK. That's what Nanabuachi also thinks as well. Let's see. Gideon. Gideon says A. Yes, it will be refused. Uh, Gideon, thank you. Susan Morgan thinks no, but they must show that they have the intention to live permanently in the UK. Susie, thank you. Emmanuel Apia thinks is yes, she will be refused. Uh, thank you, Emmanuel. Priscilla Usu says no because there's no limit on the period of absence. Okay, now let's go for the verdict. Abna Kokosa, Yao innocent, application, refusal, or not. Learn.
Right. Thank you very much. So, under paragraph RWP 6.2, couple or spouses must show relationship and that the relationship is subsisting. If the couple are living in the UK, they must show that they intend to remain in the UK permanently together. There's what we call habitual residence. Habitual residence is when you have to be in the UK always, and if you are away, you don't stay away for more than 6 months or 180 days. Such habitual residence test does not extend to intention for spouses to show permanent residence together in the UK. And so, even though Abna has a visa and must go and come early and no more than 180 ordinarily, because of her spousal relationship with the husband, she is not bound to be quick in the 6 months. And so she can be away for more than 6 months. At any point in time, she has to show that her original intention to be with the husband permanently in the UK still remains. And therefore, no, there's only intention to live permanently in the UK. C.
So Laura says the answer is C, and he's explained that each case must be judged on its merits, taking into account reasons for travel, length of absence, and whether the applicant and partner traveled and lived together during the time spent outside the UK. As he mentioned, family life and exceptional circumstances case worker guidance, which was updated on the 21st of May, 2024. So, Abra, yes, your application will not be refused, but you must show that you have the intention to live together in the UK. With that, I go over to the desk of Lawyer Charles Asma for him to give us a quick summary of what we discussed this afternoon, calculating time to indefinite leave and the considerations of paragraph 3C and no, section 3C, sorry, and paragraph 39E.
Thank you very much. So, in a nutshell, if you are applying to remain in the UK on in on I mean permanently or on indefinite leave to remain visa, you have to show that first you have lived in the UK legally and continuously for 10 years. So if you're on a 10-year route, you have to show that. If you're on a 5-year route, you have to show that even though yours is 5 years, you've still been there continuously for 5 years. What happens when at any point in time there was a break in that 5-year period or 10-year period? When there is a break, the rules say that you must make up for the break. The break might have been caused by your inability or your failure to renew the visa in time, and you renewed it after it has expired, but Home Office was kind to still grant it. In this case, they will add the time it took for them to make the decision to grant and the time it took for you to remember that you have to renew, and so you renewed it even though you were late. The accumulated delay time, you have to wait for that to be up as well before you can apply for indefinite leave to remain. So simply, whenever you think you are due for indefinite leave to remain, check whether indeed the time is accurate. If it is 10 years without break, you are fine. You make your application in the last 28 days to the 10 years. Or 5 years, you make your application in the last 28 days to the 5 years. Whenever there was a break, then you have to check when it took you for you to renew and how long it took for Home Office to make the decision. Put the two together and know that you have to wait for that time before you can apply for indefinite leave to remain. This is the conclusion from the Court of Appeal case of Afzal and the Secretary of State and 2021, and also Supreme Court case of Iyeki and the Secretary of State 2022. Both say that if you are late, you can have a grace period under paragraph 39E, but that grace period is not enough to protect you against punishment for indefinite. Therefore, the punishment is that the lateness, you have to wait and make the time for it before you can apply for indefinite. Therefore, let's remember to always stay within section 3C, which has absolute protection, and not 39E, which has limited protection. Thank you.
And you get this advice solely and professionally from BWF Solicitors, our trusted partners when it comes to the law. And they give us the opportunity to come your way every Saturday afternoon between 4 and 6 p.m. in the UK to give you that empowerment and also give you the opportunity to contact them for all other immigration issues, all other legal issues. Call them on 0208 493 7340. If you are in Ghana and you want to contact the office, you can call on 055 589 5959. In emergency situations, +44 77 127 61884. Or visit their website, bwfsolicitors.com, or on all social media platforms at BWF Solicitors. Today, we want to say once again thank you, a big one and a massive one, really, to lawyer Charles Asma for his time this Saturday afternoon, and to the BWF Solicitors family from the principal right down to the very last person, which is me, and to my production team, Shilankra, Padmo Dudu, and my indefatigable producer, Professor Adair. And to you out there, thank you. Without you, we wouldn't have had a program. So, on that, I would want to invite you to join us again same time next week when we start a new month, which is April 2025, and we dish out another wonderful edition of the program, The Community and the Law. My name is Oreku Frimpong. Have a good evening.